All right, person at the Mecosta County Jail, please state your name for the record.
Tommy Lee Aldridge.
All right, Mr. Aldrich, I'm Judge Wiggins out of the 84th District Court up in Cadillac. You're here for a fail to appear. So I'm getting some feedback. Are you able to hear me all right?
Yeah, I can hear you.
Okay. You're here for a fail to appear at a financial review hearing back on February 11th. I show that you currently owe the court $435. Is Pine Street in Everett still a good mailing address for you?
No.
What should that address be?
16640 16 Mile Road, Leroy, Michigan 49655.
Do you have a good telephone number?
No, sir.
Do you have an email address?
Yeah, Tommy.Aldrich87@iCloud.com.
87?
Yep.
Are you able to make any payment on this in the relatively near future?
Sounds like I'll be going to prison for the next 5 years, so no.
Okay. Are you going back on a violation or new charges?
New charges, sir.
All right. Do you have your guidelines by chance? Or
No, not yet.
have you entered a guilty plea?
Not yet.
All right.
Not guilty.
All right. So what I'm going to do then, I'm going to set this for a review hearing in 3 months. If you're somewhere else, we'll have to do something different. But if something happens where you're out, we'll get you back in here and see what's going on. All right.
Sounds good.
All right. Thank you.
Thank you.
Is Mr. Fleming in the class as well? Then can we have Mr. Fleming also?
Oh, polycars need Mr. Fleming.
Perfect. Just there.
Okay.
I'm at speak with Rexford County. Relax. Apparently, you owe them money, maybe? I don't know.
That must be it.
All right, sir. Are you Will Fleming?
Yes, sir.
All right. As I noted, the person before you, we're getting some echo, but are you able to hear me all right?
Yes, sir.
All right, Mr. Fleming, I show that, well, I'm Judge Wiggins out of the 84th District Court up in Cadillac. I show that you currently owe the court $1,871.40. You are here because you failed to appear at a financial review hearing back on July 30th. Is Phillips Street in Fife Lake still a good mailing address for you?
No, Your Honor. It's
Do you have a mailing address?
726 Sheridan Street, Big Rapids, Michigan.
49307. All right. Are you able to make any payment on this at all?
No, Your Honor. I've been in jail since April.
Since April? Do you have an out date?
I just got a year and a day in prison. It'll be April of next year.
And is that prison or are you staying in jail?
Prison,
Prison.
Department of Corrections.
All right. Okay, then we will put this matter on hold and we'll see how things wind up. Thank you.
Okay. Yep.
All right, person at the Wexford County Jail, please state your name for the record.
Shantae Nicole Franklin.
I'm sorry, I can't hear you.
Shantae Nicole Franklin.
All right. This is case number 262286FY, the people of the state of Michigan versus Shantae Nicole Franklin. Ms. Franklin, you met with somebody or at least talked with somebody from Community Corrections and gave them some contact information. Was that information accurate?
Yes, Your Honor.
And did you have the opportunity to meet with somebody from the Public Defender's Office?
Yes, Your Honor.
I have a complaint that alleges that on or about May 19th, 2026 in Wexford Township of Wexford County, Michigan, it's alleged in count number 1 that you committed the offense of controlled substance delivery or manufacture of methamphetamine. That is a felony punishable by up to 20 years in prison and or a fine of $25,000. You understand those charges and the potential penalties?
Yes, Your Honor.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You have the right to have an attorney present during any questioning you consent to, and you have the right to stop answering questions at any time. You also have the right to be represented by an attorney, and if you cannot afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of one?
Request the appointment of one, Your Honor.
All right, the court will make a referral to the Public Defender's Office for the appointment of an attorney. Will enter a not guilty plea and will set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution is required to prove 2 things. 1, probable cause that the crime had occurred, and 2, probable cause that you were the person who had committed the crime. If the prosecution is not able to do that, the case will be dismissed. But if they are able to, you'd be bound over to stand trial in circuit court. Prior to that preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments and the threat that you pose to the community. Historically, counsel, the only thing I show in the defendant's past is a loitering from 13, which has been set aside. The praxis scores her at a risk level 2. Any comment regarding bond from the defender's office?
Yes, Your Honor, thank you. Ms. Franklin and I got to speak earlier. She indicated to me that she has lived at her residence for 16 years, but has been in the general area for 34. She attended music high school, and she has family in the area. She has her 2 kids that live with her, ages 9 and 17. Although she kind of just does odd jobs, she keeps up with that by being out and able to serve those in the community. So we would just respectfully request a PR bond. Thank you.
Thank you, Ms. Lawrence.
This case was a controlled buy involving just under a gram of methamphetamine. Given the nature of the charge, I would ask the court to post random drug testing. I do think a monetary bond would be appropriate just given the severity of this felony, but I do understand she does have limited criminal history, so I will leave bond up to discretion of the court.
All right, thank you. While the court does not necessarily consider Ms. Franklin as a flight risk, I do consider her as a threat to the community given the allegations that she was delivering methamphetamine, along with the fact that this was a controlled purchase. So I do believe a monetary bond is appropriate. The bond will be set at $10,000 cash surety with the condition that the defendant appears ordered to keep your contact information current, not leave the state without permission, and to commit no new crimes. I am going to order no illegal controlled substances, no recreational marijuana, and random testing. I believe that those are appropriate given the allegations in this case. Ms. Franklin, if you are able to post bond, you must report immediately to the Wexford County Community Corrections Office, which is located on the ground floor of the courthouse, to get signed up for your testing requirements. Do you have any questions for me about your bond conditions?
No.
All right, thank you. Next arraignment.
Good afternoon.
Good afternoon. Could you please state your name?
Albert Antonio Montaño.
I'm sorry, I couldn't hear you.
Albert Antonio Montaño. Sorry about that. Just woke up.
All right, this is the case of the people of the state of Michigan versus Alberto Antonio Montano. Sir, you met with somebody from Community Corrections and gave them some contact information. Was that information accurate?
Yes.
And did you have the opportunity to meet with somebody from the Defender's Office today?
Yes, sir.
I have a complaint that alleges that on or about August 4th, 2026, in Clam Lake Township of Wexford County, Michigan, it's alleged in count number 1 that you committed the offense of controlled substance possession of methamphetamine. That is a felony punishable by up to 10 years in prison and or a fine of $15,000. In count number 2, it's alleged that you committed the offense of controlled substance possession of cocaine in a mixture less than 25 grams. That is a felony punishable by up to 4 years in prison and or a fine of $25,000. Do you understand those charges and the potential penalties?
Yes, sir.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning you consent to, and the right to stop answering questions at any time. You also have the right to be represented by an attorney, and if you cannot afford one would be appointed to represent you, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of one?
I represent myself because they're doing the vehicle is mine and the vehicle was mine.
I'm sorry, say that again.
I said I'll take the charges because the vehicle was under my name and everything that's in there concerns to me because I'm the one that's driving.
All right, well, and you said you wish to represent yourself?
Yes, sir.
You wish to represent yourself on a 10-year felony, which means you could go to prison for up to 10 years, and a 4-year felony?
Yes, sir, that's fine.
All right, well, I have to make sure that this plea, that not your plea, but your waiver of an attorney is accurate, knowing and voluntarily done. So give me a moment while I prepare a form and I'm going to read that to you, all right?
Yes, sir. I just do time.
How many years of education do you have?
I graduated from high school.
All right, so this form says, I am the defendant in this case. The judge has explained to me, and I understand that I have been accused of a crime, and I have read or have read to me the charges against me and know the minimum and maximum possible sentences, the nature of the charges, and that there may be lesser included offenses, defenses, or mitigating circumstances. That I had the right to be represented by a lawyer at all stages of this process, and the court will appoint one for me at public expense if I cannot afford one. That I had the right to consult with a lawyer that I hire or that the court appoints. That I have the right to act as my own lawyer. that if I represent myself, I will be held to the same standards of law and procedure as a lawyer and will not get any special treatment from the court. The risks of being my own lawyer, including that a lawyer has skills and expertise that I do not in preparing for and conducting a criminal defense, and that defense and trial, and that the state does have an experienced lawyer. Unlike the prosecutor in this case, I will be exposed to the dangers and disadvantages of not knowing the complexities of jury selection, procedure, or how to preserve my appeal rights. That because of these things, it can be unwise to act as my own lawyer. I knowingly and freely waive my right to the assistance of an attorney and choose to represent myself. I do not want to hire an attorney or have the court appoint one for me. I have no doubt about my decision. I have 12 years of education. I read and understand the English language, and I am mentally sound. Mr. Montano, do you agree with all those statements?
Yes, sir.
Having gone through all that, do you still wish to represent yourself?
Yes, sir. Because I'm just working up here.
All right. Well, you do understand that if you want an attorney, the court would appoint one for you. You may be required to repay a portion of that expense, but it would be greatly less than hiring your own attorney if the court does impose an attorney fee. Do you understand that?
Yes, sir.
And you still wish to represent yourself?
Yes, sir. I went to John. Can't remember.
What's that?
I said, yes, sir.
Your Honor, if I may, I'm not quite sure if he understands the situation with this. I know when I talked to him, like, he just more so seemed like he wanted to enter some sort of guilty plea. So I don't know if he really understands that he could still have a lawyer for that or not.
So, sir, it sounds like the public defender's office has some concerns about your understanding. So I want to go through that with you some more. Do you understand that you've been charged with possession of methamphetamine? That is a 10-year felony, which means you could be sentenced up to 10 years in prison. Do you understand that?
Yes, sir.
And do you also understand that you've been charged with possession of cocaine in a mixture of less than 25 grams, which is a felony, punishable by up to 4 years in prison, which means you could go to prison for up to 4 years. Do you understand that?
So in total, it would be 14 years.
Well, there's going to be concurrent sentencing most likely, which means you would serve the two sentences at the same time. Now, those are the maximum penalties you're looking at. However, guidelines will come into play there, and then the court considers those guidelines when it comes time to sentencing. So while you might be subject to a total of up to 10 years, the guidelines might sentence you to something less. Do you understand that?
Okay, yes, sir.
Now, do you also understand that even if you wanted to today, I would not be able to accept a guilty plea to these charges? Do you understand that? Because, one, the appropriate paperwork is not filed in front of me yet, and so I would not be able to accept that plea. And even if, let's say, for example, we come back tomorrow and you plead guilty, I would not be your sentencing judge. You would be sentenced by Judge Elmore in the circuit court up to about a month out. Do you understand that?
Okay, yes, sir.
Now, knowing all of that, do you still wish to represent yourself?
Well, where do I get somebody to represent me?
So you could hire an attorney, or if you wanted the court to appoint one, because you're indigent, which means without enough money to hire an attorney, the court would make a referral to the public defender's office, and then they would make the determination as to whether or not they would be able to take your case. I will tell you probably 99% of the cases that get referred to the public defender's office, they do take up.
Okay, I'll get one.
You want the court to appoint one?
Yes, please.
All right, so the court will enter a not guilty plea, will make a referral to the public defender's office for the appointment of an attorney, and will set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution is required to prove two things. One, probable cause that the crime had occurred, or both of these felonies had occurred. And two, probable cause that you were the person who had committed the felonies. If the prosecution is not able to do that, the charges would be dismissed. But if they are able to, you'd be bound over to stand trial in circuit court. Prior to that preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. Do you understand that procedure?
Yes, sir.
All right. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments and the threat that you pose to the community. Historically, counsel, I show the conviction for possession of a controlled substance in 18 out of Texas, but the sentence was deferred. So what that means, I'm not sure. It also looks like he has at least a charge from 23, a controlled substance charge, out of Mississippi. And there's no indication in his CCH as to whether or not that's a conviction or if a warrant was issued. It shows there's a charge. And then in 16 out of the 85th District Court, I show not a valid license, and in 21 out of the 85th, an OWI. And the praxis scores him at a risk level 3. Any comment regarding bond from the defender's office?
Yes, Your Honor, thank you. Mr. Montano and I spoke earlier. He indicated to me that he has been doing work, doing construction and concrete work. Even though he just recently moved here, he has a good stable job in that. He has family in the area. And as mentioned, the praxis scores him at a risk level 3. So we would respectfully request a PR bond. Thank you.
Ms. Lawrence?
Your Honor, given the nature of the charges, I would ask the court to impose random drug testing. I do think a monetary bond is appropriate in this case. While I understand his praxis score is rather low, I think he is a flight risk. He states in the praxis he's from Texas. He's only been here for 2 weeks. As he stated earlier, he's just here working. I don't believe he has any ties to the community at this point. And these are serious felonies, so I do think he is a flight risk, and I would ask the court to impose a monetary bond.
All right, sir, your job, is that regular employment?
Yes, sir. It's a full-time. Just started. I get paid every Friday.
All right, how long have you been in that job?
Probably a month so far, but I just got the truck and everything and was paying it off.
So are you self-employed?
No, the boss gave me the, what's it called, W-9?
Okay. So
like,
when you say you just got the truck and you're paying it off, what do you mean by that?
I bought it off somebody from around the area in Traverse. Like, we made an agreement, so I just finished paying it off and just got insurance last week. And this week I need to get the plates.
All right. I will state, while the praxis scores at a 3 based on the defendant's history with a possession conviction out of 18 and some sort of, at least a charge out of Mississippi for controlled substance, the history of drug abuse I don't think is appropriately scored, so I believe that should be rescored, which would make that a 4. That still keeps him in the same range. And while he may have just moved back from Texas, he at least had enough ties to the community in 16 and 21 to receive convictions out of the neighboring county. Or counties, I guess that district court covers 2. All right, sir, as a condition of your bond, I am going to order that you appear as ordered, keep your contact and employment information current, not leave the state without permission, and to commit no new crimes. Because the allegations are drug-related, I am going to order no illegal controlled substances, no recreational marijuana, and you'll be subject to random testing. I believe that those are appropriate given the allegations in this case and the conviction and the potential case that's outstanding in Mississippi. Bond in this case will be set at $25,000 cash surety, 10% bond. While the defendant does have some ties to the community, I'm not sure there's sufficient enough ties. But I believe with those conditions, we are able to secure his return. All right, so sir, if you are able to post bond, you'll need to come over to the Community Corrections Office located on the ground floor of the courthouse, which is about 5 or 6 blocks from where you're at, and get signed up for your testing requirements. All right?
Yes, sir.
All right, next to Raymond.
Where do I pay bond?